Good afternoon and welcome to today's presentation, Information Governance in a Big Data World. Before we begin, I just wanted to let you know that this presentation is going to be recorded and we will be sending out a link to the archive recording tomorrow morning. Today's webinar will discuss the pitfalls of ignoring a proactive data management strategy. Mr. Huston and Associates will offer the importance of having a data management strategy in place in areas that need to be covered within the strategy. They will also discuss mobile and cloud concerns, use of personal devices, as well as data assessment during litigation and investigation. To give a little background about our presenters, Sean Huston, CEO of Legal Support Partners, a firm that offers information management to legal firms. Mr. Huston has worked in operations, sales, and executive management with both small and large litigation support providers. Over the years, he has worked on a number of high-profile cases, including Enron and WorldCom civil and criminal litigation, asbestos and product liability class actions, government security issues, multi-billion-dollar second requests, major SEC fraud investigations, and thousands of other civil and criminal cases of all magnitudes. Mark Portner is a principal consultant at Innovative Development, a firm that provides information governance and e-discovery services to clients. He provides account management and consulting services to clients across multiple industries. Mr. Portner provided information governance and e-discovery services to clients including Merck, AstraZeneca, and Shire Pharmaceuticals. He has also developed processes and operational models in support of litigation demand. Michael B. Hayes is a litigation partner at Montgomery, McCracken, Walker, and Rose, a full-service Mid-Atlantic regional law firm headquartered in Philadelphia, PA. Mr. Hayes is a founding co-chair of the firm's Electronic Discovery Group, and his practice concentrates on commercial litigation, governmental inquiries, and corporate investigations. Mr. Hayes is frequently called upon by clients and colleagues to provide legal expertise, consultation and recommendations concerning electronic discovery issues. He is also a frequent speaker and writer on cutting-edge legal issues and technologies in electronic discovery and takes great pride in safely and successfully navigating clients through the discovery process. For individuals seeking CLE credits, the code word for today is big data. There will be two opportunities where we will request that you submit that word into the chat feature for CLE credits. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself. If you have attempted to log on and receive an error, or if you are listening via telephone, please email the passcode both times that is requested and state the time that you have entered your code in your email. Also, please remember to complete the survey that will appear on your screen at the end of the presentation. As a provider of CLE credits, we are required to have supportive information that you have attended, and in many states the survey is required. Mr. Huston and his associates welcome your questions throughout the presentation, and again, they can be submitted in the chat feature. Before leaving the presentation today, we ask that you take the time to complete the survey that will appear on your screen after today's program. The survey is also a CLE requirement in some states. Thanks again, and I will turn the presentation on to Mr. Huston.
Thank you, Nadja. So I just wanted to say thanks again to everyone for joining today, and also say thank you to my co-panelists, Mark Portner and Michael Hayes, for joining and sharing some of their own experiences with information governance and some steps on how to prepare and how it applies to litigation readiness. So there's a lot of talk these days about information governance, and I think it's fair to say that it is a buzzword for the technology and legal industries today. But I think it's also more than just a buzzword. It's something that people should be paying attention to. So I want to kind of pose to my panelists, what, from your perspective, is information governance, Mark?
So I think information governance is a combination. I'm going to talk through that today, right? And it's about bringing organizational policy and the various aspects and processes within an organization together in a unified process and approach to really look at how information is not just used, but also how it is governed, right? How it is managed within the organization. And again, it needs to be a unified approach within the organization. And we're going to talk more about that.
From Mike, from being the attorney on the panel, what, from your perspective and how kind of you deal with e-discovery issues and data management issues for your clients, what kind of is information governance to you?
I consider it a framework on which corporations engage in discovery and successfully engage in litigation. And if you don't have this framework in place, you're taking undue risk in litigation, and you're jeopardizing your chances of success when you initiate litigation or defend it.
Great. Now, another point is you frequently see information governance compared to ECM or enterprise content management. And I see you see it both compared and contrasted. Where, from your perspective, where do you fall in on that comparison?
I think that, from my perspective, and what we see at some of our clients, information governance sort of takes that information content model to that next level, where you're applying some of the processes and policy around the data.
I think that's a really good description of it. It's more than.
Okay, great. So I think a lot of folks who are involved in electronic discovery are familiar with the EDRM, or the Electronic Discovery Reference Model. Something a little bit newer on the scene is the Information Governance Reference Model. Can you talk about kind of what the process is that's defined within this model?
Sure. So, as Sean pointed out, the IGRM came from the same group that had put together the EDRM, the Electronic Discovery Reference Model. And really what it is it's sort of a pictorial representation of some things we've already started to talk about. Right? It's bringing together the various processes, organizations, and types of data that exist within organizations. Right? And if you look at the model, and it's circular, so we'll work our way in. Right? We see the unified governance piece around the outside, and we've touched on that already a little bit. And that's that this has to be done by the entire organization. This is not something that is IT's responsibility. It's not something that's just legal's responsibility. Right? It needs to be a unified approach. And if we drop into the ring, you see the colored pieces of the pie. We see that we start to identify the different parts of the organization that have a hand in information governance. Right? We see the business. Obviously, they're looking to use the data. Legal is assessing the risk, right, and making sure that the organization is using the information correctly and managing it correctly. We've got records information management, right, who's looking at the retention rules. Obviously, IT is a part of this, right, because they're responsible for some of the containers and applications that manage that data. And, of course, the privacy and security aspect, right, again, looking at risk and compliance. So all of these groups come together in the middle of the circle, right, and we start to talk about policy integration and process transparency. Okay, and I think those are pretty self-explanatory. But then as we get to the actual data, right, the data goes through a life cycle, and we see that the data is initially created, and it comes out and has business value. Right, it's being used by the organization. Well, that data begins to age, right? And as it ages, decisions need to be made, and policies need to be made around how that data ages, right? And do you hold it? Do you archive it? Or do you dispose it? Right? And it really depends on what the value of that information is, and then it also depends on whether or not that information is being held for legal purposes. Right? So it's the combination of those attributes of the data and what needs to be done with the data that is then driven by the model that's created by each organization.
Mike, from a litigation perspective, kind of what do you see as the value proposition for this model?
Well, I think from a legal perspective, a lot of these risk areas you can actually look at as a two-sided coin. That your legal sort of risk area and your privacy and security risk area, that those areas of the IGRM can be value propositions. I'll give you an example. Your online retailer, privacy and security of data for them is not just a risk proposition, it's an advertising proposition for them. And on the legal risk area here, I look at it as legal opportunity. If folks look at litigation as a risk and legal retention of documents as a risk, I look at it as essential to successfully litigate when you have to, whether you're initiating it or defending it. And if you look at it as a value proposition, it's not going to be so onerous for you and your employees to undertake what you need to undertake to meet your duties.
Yeah, that's I think that is an interesting way of looking at it. Instead of looking at it as a completely defensive strategy, you can look at it as a potential growth strategy in some areas, or offensive strategy should you need it.
I'll give you another example of that on the legal side. If your company has intellectual property, it's not just risk. There's risk that you're going to have data leakage, but it's opportunity that your retention of data may help you protect your IP. And if you don't have good, rigorous information governance, you lessen your ability to protect it.
Yeah, I think that's a great example, and I think that the trick is finding the balance, right? It's finding a balanced approach to managing that information.
Yeah. No, I think that's a great point, and easily, kind of in the, kind of crisis type of discussions that wind up usually being the topic or for this type of thing. I think that's actually something really good to keep in mind. So we talked a little bit about what is information governance, and the general model, how it can impact you from a legal perspective, from a business perspective. But with any business process, individuals need to own it. There's actually people involved making this stuff happen. I think one issue is that we kind of touched on was information governance isn't a software solution that you install and implement. It's a business process that touches the entire breadth of your organization. And again, that gets down to people. So who, from your perspective, and from, I know, Mark, you've implemented some of these policies from within corporations. Who do you see as best to kind of be the stakeholder to take on responsibility of some of these things?
Right. So we've talked a little bit about this, and I think that, when we say who owns it, the organization owns it, right? It's not an individual, it's not a department, it's not a group. It's important to remember that this is a shared responsibility across the organization. Now, ultimately, within an organization, people tend to appoint someone to be in charge of it, right? They'll create committees that will govern this. I've seen this run out of IT, where the CIO of an organization might have the responsibility, and I've seen it run out of legal, where a chief compliance officer might have responsibility for it. So I don't think it's important to necessarily define who, as an individual, defines it, but really to define how an organization runs it, because the organization has the responsibility.
From in your experience, Mike, for your clients that you help with these issues, who do you wind up kind of being dealing with on the corporate side?
In the past, it's been legal and IT and IS. But I think as time goes on, to Mark's point, this is an organizational issue. And information is the lifeblood of business. And there's more of a recognition of that now. So it's easier to get broader buy-in, I find now, than it was maybe even 2-3 years ago. where you'd go in to talk about these issues and you might get eye rolls from people in a room. You don't get that anymore when companies like Facebook and Google are making money hand over fist with information every day.
Yeah, Mike, I agree, and I think that in the past, oftentimes you saw turf wars, right, where certain departments or certain leaders within an organization would try to be responsible or take the responsibility for managing this. And to your point, I think that as information companies have become more the standard, we're seeing more of an organizational approach.
Now, I guess that kind of touches on a follow-up question I had, which was, do you ever run into situations where there's individuals or departments that want to kind of avoid the topic or avoid assuming those responsibilities for their organization at all?
I see more, I'll call it a Game of Thrones activity, where you've got departments within a company, the House Stark or the House Lannister or something, and everybody's got their own way of doing things. And there can be resistance to change and resistance to a unifying information governance approach. I see more disparity than resistance to the idea.
Okay.
I've observed resistance, or maybe it's fear, at some organizations where if information governance is being implemented in support of recent litigation and business areas hear, wait a minute, there's litigation going on, they're very reluctant to jump right in, even though the legal group or the compliance group, whoever's driving this, needs them to be at the table. There's definitely, again, to your word was resistance, my word is more fear or apprehension.
Okay. Yeah, I guess we'll kind of get that. You want to keep your people below the rated hard as much as possible.
That's right.
From talking about that, it is a process to be implemented, and there are stakeholders who, when it comes to the specific implementation of the processes, who winds up being those individuals.
You got to talk to Mark on this.
So I think it's a combination, and I think it depends on what part of the process you're talking about, right? For those pieces of the process that are very IT-centric, right? The IT leadership that's part of the Information Governance Committee, right, needs to take control of that, right? And they have accountability for that. And they have accountability not only to their own department, but back to the committee and back to the organization, right? For legal processes, same thing, right? They need to take accountability for their piece of it. And if we think back to the information governance reference model that we saw earlier, right, it's purposely drawn as a pie, okay, because there's each aspect of that model, and each group needs to take responsibility and show accountability back to their peer groups, right, to show that they're managing their piece of it.
Okay. Yeah, when you look at a pie or even a wheel, if a part of that is missing, if one of the spokes is missing, you're not going to be moving forward. You're going to fall off the tracks. From, obviously, and I'll, can touch on my own experiences, when having different groups, both with different objectives, but also that are culturally different within a business, how do you kind of bridge those barriers, say between legal and IT or, some other technology department or, another business department? Because sometimes, it's not unusual to hear people talk about, IT speaks tech, the legal folks speak legalese, and there's just two separate languages that, neither side understands the other person's language. How do you overcome those potential issues?
Well, I think giving an advanced preview of what's going to be required is key. That if you're going to need that cross-selling and cross-involvement, you got to let your initial point of contact know that you're going to need that, so they understand that you're going to need their help to bridge those gaps. If you don't give them that advance warning, then everything comes as a surprise, and I find it's a much tougher road to hoe.
Yeah.
So try to give them a heads up of what it's going to involve.
Sean, I think we've also seen at many of our clients that some of those barriers that you just described are really coming down. and there's less of that language barrier between the different departments, right? So the IT groups are now more knowledgeable of legal needs, and legal has a much better understanding of the information technology world. So I think that it's moving forward, maybe slowly, but definitely moving forward.
Good. Yeah, and I mean, my experiences are fairly similar. I mean, one of the, I wound up falling in the kind of in the in-between stage and trying to bridge that gap for some of my clients to the technology folks in terms of where to get data, how to best use it. I think to your point, that dynamic is changing, and there is more understanding, and I think part of it helps just knowledge, just the general knowledge of individuals from the technology side. But I also think it helps when the folks that are in technology understand some of the business case for what they're being asked, and sharing some of that. I've found, dealing with internal IT departments to be helpful, instead of saying, you need to, do this, preserve this data, and let me know what else you have, that's related to this. Share some of the why you're asking, and the benefit or risk associated with the business for it, because it's a completely different conversation to have, and sometimes you can learn things that you otherwise didn't know about what, maybe they have information that you're not even asking for that could be helpful to what you're trying to do. So whether it's obviously on a broad information governance plan or responding to a specific discovery request.
Sean, I think one other point just to add to that is it's important also to understand where the organization is in the urgency that they need to implement this, right? If they're being proactive and they want to put an information governance policy in place, but they don't have pending litigation, right? They might not react as quickly. They might keep some of those barriers up that we've talked about. But if there is litigation pending, companies seem to move much faster.
Yeah.
Right?
Yeah, I would definitely agree with that. From now, we're going to take a little bit of a step back and talk about kind of the why of information governance and information governance policy. Mike, can you talk about why you think companies should be focused on implementing a proper information governance policy?
So looking at it from a pure defensive standpoint, which I don't necessarily ascribe to, but looking at it through that lens, if you don't have good information governance, you are going to do triage every time you're in a litigation and you've got any kind of discovery to undertake. Again, it's a framework on which your discovery efforts are based. If you don't have that framework, you've got to build it using matchsticks whenever you have litigation hits. And we're going to talk a little bit later about a couple of cases where companies have done not such a good job on the discovery side, and I would venture to say it's because, in large part, they didn't have the best information governance to serve as their basis.
Yeah, and I think that's a good point, and one of the points on the slide here to remember is that defensibility starts before litigation actually begins. So what you do, before you get word that you may have a pending litigation and you need to start thinking about performing a legal hold and preserving some of that data. What you did prior to that has as much, and correct me if I'm wrong, maybe more to what you can go to court and say that your processes are defensible in court.
Yeah, it's one thing to say that you're implementing a hold, but if you don't know what you're holding, it's useless.
Yeah,
I think that's the most succinct way I can put it. If you don't know what you're holding, good luck showing that it's defensible.
And from in terms of specific things that policy, information governance policy can deliver, what are some of those things that you see, some of those benefits, kind of when you're in the heat of battle, so to speak, with the IG, with IG policy? What are some of the benefits that can be gained from those things?
I think that one of the things, and when we talk about this, we say that it starts before litigation begins. You don't want to be building this while you're, to use your word, Sean, in the heat of battle, right? One of the tools that we implement for many of our clients is we put playbooks in place, right, where we map everything out. They understand where their data is. Their data maps are created. They understand their retention and deletion policies, and it's all mapped out so that when you do go into battle, you've got that playbook. You understand what needs to occur, when it needs to occur, and who needs to be involved. So we've had great success with that.
Yeah. I mean, I think that's a good point. I mean, when it comes to knowing where your data is and using things like data maps, and I think when you use a term like data map, I think people say, oh yeah, that sounds like a good idea, but there's a lack of understanding of, okay, what does that mean? What does a data map show? What does it do? You know, what information does it need to have on it? Depending on the situation, obviously, but, we deal with litigations from, a smaller, employment case, all the way up, to, billion-dollar second request, kind of get the company litigation, what would be considered massive litigation. And on the smaller side, I still think having data maps and things like that in place, preferably beforehand, although still too many times, by the time we're brought in, it's already, your litigation is well down the road and, your people are fighting over, discovery terms. But, even in those situations, I find it helpful, although it's triage, to still map those things out so they know where the holes are, that maybe that they haven't plugged. And I think it can be as simple as, mapping out, who the custodians you're dealing with, and what data they have access to. Are they using Exchange server email? And where does that live? Does it live on a laptop? Use the server data to consider. Do they have it on a home computer? Are they using webmail, things like Gmail and Yahoo? I mean, those are all potential issues, and liabilities, kind of in the data sphere that need to be accounted for. And in a huge organization, I mean, the risks, I think, are just, compounded exponentially.
Mark mentioned the playbook. I think that's a really appropriate analogy for this, having the playbook. And when you don't have good information governance, you get into litigation, it's the opposite. It reminds me of the Waterboy movie, where the Waterboy in the football game is the guy who has to catch every pass. And they say, well, how about on this play? You go out to the right, Waterboy, and you go catch it. You get into litigation without information governance. You got no playbook, and you're hoping that you got the Waterboy to catch the pass before the game ends. It's not a good place to be.
I think, that's, I agree. I do like the playbook analogy. So obviously, in talking about any subject, I'm not a fan of kind of alarmist tactics or scare tactics. However, there's real issues when it comes to data, data management policies, and I think at least I know for me, every time whether I open a newspaper or go to some of the websites that I get my news from, it's hard to go a day without there being some news story about some data breach or some security concerns regarding data. What are some of the risks that you both see, for not having the proper systems and policies in place when it comes to information governance and data? And I know we obviously talk about, everyone knows, the NSA issue with Edward Snowden and how he was able to get in. And actually, there's an actually really good article I know, Mike, that you had on what was the proposed way that he got the data. Which, looking at it, and we can send the link out to everyone after the fact. But it seems pretty generic. Some of the things that he probably did, and just standard IT type stuff, and he was able to clean, to copy all the data off. So, kind of, what do you guys, from your different perspectives, what are the risks that are for not dealing with this stuff?
So to preface it, I think information governance should be sold as an asset, as a positive thing, as improving the inventory and the lifeblood of corporations. But if you need to highlight risks, to push it, to get it moving, here are some. One is, I called it the Snowden problem here, is your IT, your IS personnel, they are the keepers of your most sensitive information. They are, if they're not good assets for you, they can be a huge risk. They are that more valuable and a riskier proposition than most companies take heed to. But aside from that, information has value, and anything that has value is something that bad folks are going to go after. And so you have the external problem that we see where you've got external hacking, folks who are looking for data breaches, looking to take advantage of data breaches. We had the Heartbleed vulnerability all over the news over the course of the past several weeks. So you got to look at the risks that are attendant to having all this data within your company. And if you don't pay attention to it, it's not just bet the bank, it's possible to lose the bank for companies, as we've already seen.
Yeah, and I think, and so to that point, there was a very recent decision which basically gave the FTC the right to determine what was reasonableness when it came to data security. Now, my understanding of it was going to be more along the lines of after there was a breach, as opposed to proactively looking at policies prior to there being a potential breach. But still, you don't want to be post-breach when it comes to data. I mean, it's too late at that point. And then the damage that I think that can do to a company's reputation is significant.
For our listeners who are in private practice or folks who are in-house, pay heed. 46 states have personal data breach notification statutes, and it's only a matter of time until the federal government institutes one. And that's not just imposing obligations to notify after a breach happens. You've also got unfair trade practices and deceptive trade practice statutes across the states. And you've got the FTC now, as you mentioned, it's a District of Delaware case that just came down, saying that the FTC has the authority to engage in enforcement actions, finding that if your company doesn't engage in sufficient data security measures to protect our personal data, customers' personal data, that you're subject to an enforcement action for unfair trade practices. So you want risk, you want potential liability, there it is, and it's only going to expand. I think the Target breach, I think there's more than 90 class actions now, and they're going after the same theory. It's a consumer protection theory. So you want risk to drive your information governance? How about avoiding 90 class actions because your data security was insufficient?
It's important, and what's unfortunate is that many companies react as opposed to be proactive, right? And they don't really think about many of these things. Like, everyone is concerned about hacking, but they don't put the real policies in place that they need to secure this information proactively. And to your point, right, they're paying the price retrospectively.
Yeah, man, and I think you also look at, obviously, kind of immediate issues, and I think it's easy to think in terms of immediate litigation issues, but how much, and I forget what the number for the weeks after the Target breach for the reduction in their sales numbers was significant. So, I mean, there's obviously issues, when it comes to managing litigation, but if it's also doing damage to your business. So that cost, whatever that cost is from a number side, dealing with a specific litigation, the potential costs are much, much higher. From now, what about this? You have there's a citation here in terms of the DuPont case. Is there some specifics you can give on that, Mike?
The DuPont case is it's a good case to take a look at as far as protecting your IP. Is it a technical data leakage case? No. EI DuPont got a substantial verdict against Cologne Industries on an IP litigation, hundreds of millions, and it got reversed and sent back for a new trial because evidence had been excluded at the trial level that DuPont had not protected its intellectual property, the trade secrets. Was it a technical data leak? No. But I think it's a good decision to take a look at, again, for the value proposition, the positive side of the coin, protect your IP. If you don't protect your IP, you're running a risk. You're lessening your company value.
And I think and then kind of, there's all, talking about these, compliance issues, when it comes to notifications. There's obviously specific issues when it comes to HIPAA violations with some notification requirements there. But that, also spreads just across the board. Where that seemed to, some years ago, maybe that was, HIPAA was probably kind of making it official for medical records and medical information. It seems to be, kind of bleeding into every other aspect of data that may exist anywhere.
Well, with convenience comes risk, right? And I think the general population is waking up to the fact that the convenience we've enjoyed in recent years to, for example, buy something using your smartphone comes with risk. And companies are going to be valued if they protect that information that we share to make our lives more convenient.
From in terms of additional risks, Mark, what do you see from a storage cost issue? I'm curious from that perspective in terms of they're holding too much data or just trying to manage volumes of data that maybe you don't need, and you kind of like how you were saying in terms of data aging, not kind of culling it out when it's old and not useful anymore.
I think you have a couple factors that are occurring. I think the first is that organizations are becoming smarter on how to manage their data long term. Right? In the early days of e-discovery, people would panic, right, and they would retain everything. And I think organizations have realized that they don't need to retain everything. I think additionally, the tools on the market are improving so that you can pull data dynamically. You don't always have to hold everything. You can pull it as you need it. There are times where you do need to freeze it and put it into a stored location. But I just think that with, again, the improvements in technology, organizations becoming more educated on litigation needs as it relates to data, I think storage costs, are improving. Right? I shouldn't say the costs themselves are improving, but the way the companies are utilizing it is improving.
Yeah, and I definitely think people are getting smarter about it. This is probably about 8, maybe 9 years ago. I was approached from a financial corporation who will remain nameless. But they were under a legal hold, and their initial hold of data netted 30 terabytes of data. And they, after probably about 10 or 12 days, they reached out to me, and they were adding an additional 3 terabytes of data to it daily, from just backing up everything because that's what they were told to do, and that's they were asked to hold the data, so that's what they were doing. And there's obviously the majority of it was duplicative data, and but they were under the impression that again they needed to hold everything, and they didn't have policies in place prior to that happening to alleviate those issues. That eventually that didn't wind up well for them, in terms of general issues. But that I think is an example of the potential extreme of doing things poorly and the risks associated associated with not having something in place and being fighting off a litigation. Then, I mean, the issues, when it comes to storage, in this day and age, the storage cost, the cost for, hard drive, isn't, potentially a large sum, but that's not just the only cost associated with storing data. I mean, there's a lot more to consider. And back in those days, they were looking at a 7-figure sum to start managing that data at that point, and put it into some, useful context and useful form. So, it's an issue that I think early, kind of proactive activity can,
Sean, I think that takes us back to an earlier slide, right, where if you've established the data maps, you've established the playbooks, when it comes time to store or retain data, you know where to go. Right, the point that Mike made earlier, if you're asked to do a legal hold and you don't know what to hold, nor do you know where it is, you're going to hold everything, right? And that's going to drive up your storage costs potentially. So to your point, Sean, that early preparation, being proactive, creating those playbooks or a similar type of tool is essential.
And I think also from the legal perspective, you're holding that data and kind of feeding all that data into the e-discovery funnel. Your e-discovery costs, are going to be significantly compounded from there.
Yeah, no question. And everybody knows that the biggest discovery cost you're going to get in a significant discovery is going to be your review costs. And that's not acceptable. If you do what Mark's suggesting, if you do information governance right, you're going to be able to retain smart, and you're going to be able to spend less. So moving on, we talked about the risks. How do people, kind of going from that to, okay, we know we don't want to go be in those situations. Mark, how do you start, implementing, one of these processes and put something in place?
I think, it comes back to a point that we talked about earlier, and that's really what is the urgency for the organization, right? And as we see on the slide, it says start small. That's obviously the best way to begin, right? Because you can put the right pieces in place. You can establish your committee. You can bring in the groups and departments that need to be at the table and have accountability for this, right? But there are times where litigation hits, and Sean, you referenced a couple where you just got to jump in, right? So sometimes you can't always start small, but you still have to follow the same process, right? You need to get the right people at the table, and you make it scalable. Whatever you build has to be scalable for the organization.
So, and what about from your perspective, Mike? Where are your clients? And I know you work on kind of both with clients who are a lot of times in the midst of a dispute or entering a dispute. But either from that perspective or clients that you help kind of prior to, how do you recommend people get started?
So sometimes we get asked to help clients with litigation readiness, and we want those clients to have good, strong information governance as part of their litigation readiness, and to get help from companies like Innovative to get that IG piece in place, and if it's not in place, to get it going, so that we have a good basis on which to have defensible policies.
And one thing I want to note on this slide, there's the question posed: where does it end? Okay, you have, even if you put a policy in place, when can you say, okay, the policy is buttoned up, and we can move on to things that make us money or whatever as a company. And the slide mentions that it's a constantly evolving process, and you constantly improve. That's something that seems, at least on the surface, that it could be daunting. That I'm never going to be able to stop, doing this and take this off my plate. What are some of the causing factors that lead people to have to update their policies or update their practices.
Well, there's a reason that the IGRM model is drawn as a circle, right? It is continuous, right? And it does not end. And as long as an organization has data, new data, old data, held data, whatever that data is, right, these policies have to be put in place, right? You can't just stop. It's very different than, say, the EDRM model, which is linear, that has a begin and an end, right? Because there's constantly new data being created within an organization.
And I think another point would be if new systems are being brought online or new policies. And we'll touch on it briefly in the upcoming slides. If your company decides to go to a BYOD model, which stands for Bring Your Own Device, and that basically is your employees are allowed to use their own personal devices for business purposes. Obviously, things like that coming into play. We're implementing a new system, whether it's maybe a CRM system for your sales team. Those things, I think you have to factor into, okay, how do they play into our IG policy?
Yeah, and I think, touching on the BYOD, people having mobile devices has introduced an entirely new set of complexities to this, right? In the past, it was very easy to lock down someone's laptop and control how they access data, what they do with it. Now people can grab, their smartphones, right, and drill into systems and get pretty confidential data just while walking down the street with a phone.
Yeah.
So it's a different mindset, and it's a different set of problems and issues that need to be confronted.
Yeah, that's definitely a different
We ask that everyone submit the CLE code word now in the chat feature. Thank you.
And kind of one follow-up on that, from a litigation perspective, and being if someone's involved in litigation, or even and in the terms of litigation readiness, is there ever any recommendation to focus or start the practice or the policy on maybe high-value data as opposed to just a more general holistic approach? Is there ever any benefit to focusing on areas that might be potentially hit for something coming up?
Well, I think Mark said it right. When you're looking at starting this out, you got to look at your high value and your high risk, your high urgency areas to get the ball rolling. Once the ball's rolling, you can take a more holistic approach. I think the same thing applies to litigation and litigation readiness. You got to identify your areas of greatest risk. I think you should start there. Those are your number one priorities. But you got to take a more comprehensive approach unless you know with absolute certainty exactly what kind of litigations you're going to have from here to forever.
Yeah. Now, from obviously we talked about where do you start, but also, I guess the question comes up, when should you start to start thinking about these issues? And we have and on the slide we have the results of a survey where people described where they were in the process of instituting or thinking about instituting an information governance policy. I'm curious, Mike, what do the results of this survey tell you about the litigation readiness of the different organizations who may be involved? Obviously we have a percentage that have no plans, have a plan but then started it, aka they have no plan, and kind of going into the ones who have something rock solid in place.
I think I was surprised by this showing here because my experience with our clients is that this may be a little bit optimistic in the numbers. 30% with information governance well incorporated in enterprise-wide information management strategies. I'm not so sure that's a really accurate reflection of the large, medium, small entities out there. I think I would think the number's actually less than that.
Yeah.
To have that. But the other thing that this chart does that I think is not, the thing that's not reflected here is that this is, information governance is not a destination. It's a process that changes. And so this suggests, planned but not started, incorporated in, standalone policy. If those things are static, they're going to lose value over time, just like the oil in your engine.
Yeah. Yeah, that's something I ask you. Curious, Mark, what's your kind of perspective on this?
So just to build on what Mike said, I agree. I sort of anticipate the numbers being a little bit lower as well. And I think part of the challenge, right, is for those organizations that are not as far along in the process, right, depending on who you talk to in the organization, you can get a different result as far as how they are assessing their IG readiness, right? And that, again, comes back to them possibly not being unified, not having a solidified approach. So these numbers could be skewed a little bit just because of who they're talking to.
Yeah.
Right?
Yeah, and I think one thing that we want to propose to the all the listeners, and maybe kind of spread forth from there, is where obviously you don't have to answer here, but where do you think your organization fits into this diagram? Where would you have answered, or where your organization have answered? And do you even know where your organization is?
And does the person sitting in the office next to you agree with what you just said?
Yeah.
Because everyone's not always on the same page.
Yeah. That's but that's also. That's kind of what we were talking about earlier in terms of who the stakeholders and getting everybody involved. And how do you deal with those issues? Kind of along those those lines, asking when to start. From both of your perspectives, what do you think regarding that question?
So I've been asked that question by usually new clients, and my answer is always yesterday. So you should have already started this, right? And that kind of gives them the hint to say, all right, we better jump in and get going. And hopefully they're not involved in litigation at that point and they aren't being proactive. But yeah, my answer is always yesterday.
Yeah. What about you, Mike?
Agreed. And a little bit of build on that. Just because you should have started yesterday doesn't mean you should rush through and do a bad job. It means you should have started yesterday. We should get on this now and let's do it right.
Yeah.
Great point.
Yeah, and to that point, I think it's, you have to, I think it can be intimidating to hear that if someone hasn't done something to date, that, it's almost an impossible mountain to climb. But I think starting something is better than, doing nothing. And I have the same take on it. And from focusing on e-discovery, but frequently, kind of like I alluded to earlier, we are brought into the situation after the damage has been done, when it has come to the legal hold, what's been agreed upon in terms of discovery, and then, we're brought in and asked why we can't kind of fit into this broken framework that's been created. And I think early intervention is always better. And there's plenty of resources I think available these days. We're not talking about these elusive things that no one really knows kind of what they are or how to find more information on these things. So I tell people the earlier you get started, the earlier you have information and have potential help, even if there's no one in your organization that can kind of wrap their heads around the situation. There are people and organizations that can help and will gladly help. Even from like I said, on the e-discovery side, we're brought in, even post collection a lot of times, and then asked to do miraculous things with data sets that are just impossible because it wasn't done right from the beginning. And that, I think, starts at an information governance policy and then builds from there.
Yeah, Sean, when you talk about resources, I know on our innovative development website, we have several white papers that we've authored that are a great place for people to start. If they have questions, they don't want to reach out to someone yet, you can go out there, grab one of our white papers, and it'll definitely kind of give you a framework of where to start.
And if there's interest from any of the listeners, we can send the link or send those white papers out to everybody to have as a resource. I'm sure, right, Mark?
Absolutely. There's self-serve out on the website, or just send us a note and we can send it over to you.
Great. Kind of talking about additional concerns, other topics that fall into this. We mentioned the BYOD policies. Have either of you gentlemen seen, kind of a BYOD policy or mobile issues generally affect retention and IG policies?
I can say from our perspective, we see that every day at some of our clients, where we're being asked to collect data from mobile devices. Mobile devices have confidential information on them. They're being lost. There's a lot of issues out there. So, yeah, we deal with BYOD every day.
What about you, Mike?
My firm was recently involved in a representation of high-profile court-martial proceeding that was highlighted in the New York Times. And I can tell you that the mobile devices in that case were huge, a huge part of the representation, and we're seeing it more and more. And ignore the perils of BYOD at your own risk. It has tremendous value for business, but if you ignore the information governance aspects of it, you're taking a huge risk.
Yeah, and I think I think it's still too many occasions, and it's something that we see as an issue raised. And I think from an e-discovery perspective, and I think that one thing to consider when you're talking about multiple devices, whether they're company-owned and controlled, or it's a BYOD policy where it's a personal device used for business purposes, is that essentially it's a mini computer walking around with an individual everywhere they go, 24 hours a day. So it's your data out there in the world, walking up and down the street. And wherever they go, your data's going. And I think that's something to consider, whether you go on a BYOD policy, or, more traditional mobile policy, but also just when dealing with trying to create a data retention policy and an information governance policy, mobile data, is an issue. And, you figure, your client, whether you're inside counsel or outside counsel, your clients or your custodians or whatever you want to call them are creating new data, every day from these devices, whether it's email, social media, text messages, and how do you address that I think is an issue. And along those lines, cloud storage, John call it BYOC or bring your own cloud. When you talk about things like Dropbox and Google Docs and, all the webmail I lump into this, is you have people using their personal accounts for business use. And I think, if you go under the assumption that people are not doing it, you're fooling yourself. I talk to people in firms, in corporate environments all the time, and you seldom come across any organizations where people won't readily admit to doing it. And they're using personal accounts, they're not using a business account. The business doesn't have access to it. It's something frequent. And I'm just curious from your perspective, how do you see companies dealing or not dealing with that?
Well, I think it's another form of data container, right? And in the past, we would worry about hard drives on a laptop, on a desktop machine. Now it's a container that's out in the cloud, right, which is very difficult to manage, very difficult to know where the information actually is. To use your point, Sean, people are using personal storage areas for business documents. How do you know that? Right? So it's very difficult to manage.
Agreed.
Yeah, and I think, again, there's, we talk about the efficiency of the American, productivity and efficiency gains of the American worker, over the last, however many years. And it's tools like that which I think help, increase that productivity, but there's also a risk there. But there are legitimate, business cases for using some of this stuff, but there's also concerns, and I think if businesses could provide, work to provide and talk to their people about why they feel the need to do some of this stuff, you could possibly remediate some of the use. And then kind of a couple last concerns, issue with legal holds and data assessment. Mike, you mind briefly, I know we're coming up on the time constraints here, talking about the case you have?
Yep. So I would recommend to our listeners to take a look at the Prodoxa case and also the Day versus LSI Corp if you get a chance. Prodoxa is great, a good read because it's a great example of how reactive behavior can be very dangerous. You'll see in the Prodoxa case the significant sanctions imposed, I think nearly $1 million. And the theme that runs through it is that the entity that was sanctioned behaved in a reactive manner in discovery and with respect to their data. And I think one point that I saw in here that I just highlighted when I saw it is one of the headlines was, "The duty to preserve is not defined by what has or has not been requested by opposing counsel." The sanctioned party said, well, they didn't ask for it. Well, that's not how we get defined or how we're going to judge. And so I think it's a good read for in-house counsel. I think it's a good read for outside counsel as a reminder that you can't afford to be reactive on this stuff. You got to be proactive or you're at risk.
Yes, I think that's a great point, and actually a great way to end the discussion. And I again appreciate everyone joining us, and appreciate Mike Hayes from Montgomery McCracken, Walker and Rhodes, and Mark Fortner from Innovative Development for joining.
Before we end today, I just wanted everyone to please submit the CLE code again. And I actually do have a question. With regard to companies using like social media for, company business, like Facebook, you can log on as yourself, but you can also have like a company page. But you have to like switch between the two. Like how does that work? Like is that a breach as well? And is there like information that crosses over between the two accounts?
A lot of companies have social media policies, and if you don't have one, you need to get one to help govern how employees are going to behave in social media, and to make sure that from a company perspective, you're covered if an employee goes off the reservation and does something that they shouldn't on social media. Firms like mine handle social media policies. I'm sure Innovative handles these issues too and can have some information governance.
Yeah, and I think that's it's an interesting question, and especially, I know with Facebook, their company pages require management by a personal page. And I think that is a wrinkle with those things where it is tied to people as individuals as well. And there's been issues and questions about, who owns someone's LinkedIn account and who owns all those connections. And that is, and there's been battles about that. So those are real issues to be addressed as well.
Yeah, and the users of those tools have a responsibility, right? If they're not using it just for social purposes, and they're using it for business purposes, they're representing the organization they're a part of. So there's a responsibility with that.
Yeah, and it goes everything, obviously Twitter and blogging, and including comment sections after articles. If you go and blast whatever the article said, and kind of engage in a flame war, and it comes up about the company that you're involved in, things, I mean, those are issues that corporate entities need to, I think, address in these policies.
I think those are all the questions that we had. I definitely wanted to thank John Huston, Mark Porter, and Michael Hayes for joining us today for this webinar. Again, this was recorded, so we will send the links out tomorrow, in addition to some of the links that Sean brought up about cases and interesting information. Again, for the CLE information, we are, if you're in California, Illinois, Minnesota, Missouri, New Jersey, Pennsylvania, and Texas, as long as you included the CLE code twice and you submit the survey that will display on your screen when I end this session, you are eligible for the CLE credit. In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and document management solutions, free interactive webinars, research reports on expert witnesses like the Challenge History Report 2.0, Professional Sanction Search, and Expert Profile 360. Again, thank you for joining us today. And if you have any questions or you are interested in viewing this recording, again, I will send the link out tomorrow via email, but we also house it on our website in the Knowledge Center. And if you have any follow-up questions or comments, please email Carol Kowaleski, or you can email Naja Samuel. Thank you.